Steinglass said Hicks cried because she knew she had destroyed Donald Trump's defense. I can find nowhere in the evidence that Hicks said, I'm crying because I know I destroyed Donald Trump's defense. Is it not true that you cannot argue facts not in evidence on closing argument?
You can't. Now, I will say this about that. You can draw inferences. You can say you saw her cry. Here is the best reason that you can come up with for her crying. I'm not as offended by that one because I think the prosecutor was free to say, this is why she cried, and Trump's lawyers are free to say, no, she was crying because she didn't think Trump had done anything wrong, and the prosecutors were trying to use her to put Trump in jail.
But they can't say that because in New York, the prosecutors go last.
That was the worst part of the procedure, and apparently there's no complaining about that. But the prosecutor said everything you've read after the defense had closed, and there was no way for the defense to come back and say, well, that's bullshit.
They can't because they're done.
It's too late.
They've said what they've said, so they can't get up and say anything. That just hangs out there. I mean, they can stand up and object during closing, right? That's not good form, but I guess you can.
You can. And, we don't know exactly what those lawyers did to try to stop some of what was happening, what they said, actually, at least I don't. But you can start making speaking objections, and that's where instead of saying, that's not in evidence, Your Honor, you say, Your Honor, he knows good and well that that is not in evidence. That's just his wild guess, and he's wrong about it. What she really was crying about was, they could have done that, and the judge would have slapped them down, and the jury would have seen the judge slap them down, and it probably would have been ineffective. So they were between a rock and a hard place, Trump's lawyers.
If you would, talk about Hornbook law or black letter law. What does that mean?
It is law that is settled and that no lawyer, no judge should dispute. It's been settled for a long time.
Case law,
interpretations of statutes.
Examples would be that guilt must be proven beyond a reasonable doubt. Negligence is failure to use ordinary care.
Yes.
It's just things that everybody knows it.
Yes.
There were Hornbook rules violated here. And one of them we talked about that if A has a plea of guilty, it's inadmissible in a related criminal case against B, and that was violated here.
Correct.
And it was violated here because Cohen's guilty plea came in. He took the stand, confirmed it over and over. And a second one is evidence whose unfair prejudice outweighs the probative value is inadmissible. That was violated as well. Is that something that will be reversible error in your opinion?
Yes, after the election.
Yeah, after the election. Threatening someone with what they can be cross-examined on is a third example. If these things are all black letter law, if these are Hornbook, was the judge in on this, or was this something where the prosecutor just got on a roll and was getting away with things and be careful what you ask for? Or is it just he doesn't care if he gets, like you say, I don't care if I can hold this on appeal or not. Doesn't matter.
The judge did seem hostile toward Trump's lawyers, and he did allow a case that should have been stillborn to proceed. So I guess the way we should think about this is damning to respect for our judicial system and for the rule of law. When you have a case so infected with prejudice and bias and judicial errors and political prosecutions to serve a political purpose, the whole country is concerned about it. There are even, as I'm sure you've seen, many learned commentators on the left who have arched their eyebrows over a lot of what happened in this trial. It just wasn't right.
Was the goal here to just be able to say convicted felon?
I believe that was clearly the prosecutor's goal, and I think the judge was comfortable with that result.
The ABA standards 3-1.2, functions and duties of the prosecutor, read as follows. A, the prosecutor is an administrator of justice, a zealous advocate, and an officer of the court. The prosecutor's office should exercise sound discretion and independent judgment in the performance of the prosecution function. B, the primary duty of the prosecutor is to seek justice within the bounds of the law, not merely to convict.
That's a very high standard. And let me give you an example of how it was recently met. Scotty Scheffler got arrested by a cop who accused him of ignoring his commands and dragging him along by the side of his car. Scheffler said, I thought I was doing what this other cop wanted. I didn't realize you were holding on. It was just a mistake and a miscommunication. The prosecutor in that case looked at all of the evidence, talked to the cop, looked at the cameras that had recorded this and said, I can't prove a case here. I'm going to dismiss it. But he had been charged by the cop with a felony for assaulting a police officer. That's what a good prosecutor would do when someone brings a case to him. He would look at it, can I prove it? And then say, no, if I can't, well, I'm not going to bring this case. That didn't happen here. These prosecutors did not meet the bar that you just read.
When he was on the campaign trail and he said, I'm going to get Trump, at that point, should he have recused himself?
Well, you mean, of course, he wasn't the DA yet, but when the case came before him, he should have either declined to prosecute it or himself, just saying there's no case here, or recused and said somebody else in New York needs to bring this, not me. Because he had demonstrated bias. It is the same bias, by the way, that the federal judge in charge of the federal case against Trump, accusing him of wrongdoing in connection with the January 6 riots, that judge, before she got that case, said on the record, in effect, in substance, Mr. Trump belongs in jail. She said that in response to one of the defendants she was sentencing, a rioter, someone that broke into the Capitol. He was saying, well, I was just doing what Trump wanted. And her answer was, well, he's not here. He should be. So she has admitted bias against Trump. And they asked her to recuse. Trump's lawyers asked her to recuse. She said, no, I'm not going to. This judge was also asked to recuse, but for different reasons. And they, to me, are less compelling. That different reason is that his daughter was a Democrat fundraiser.
We asked you how the prosecutors described their case. You said directly from them, they said it was a conspiracy to help Donald Trump get elected through illegal expenditures, to silence people who had something to say about his behavior, using doctored corporate records and bank forms to conceal those payments along the way. It was election fraud, pure and simple. But conspiracy was not in the indictment.
It wasn't.
You just corrected me. I said co-conspirators. You said, no, they were accomplices, not co-conspirators. That wasn't in the indictment.
It wasn't. And a number of people who are, I think, have a deep knowledge of criminal procedure have said, and I agree, if it's not in the indictment, you can't prosecute somebody for it. What the state did here was put a whole bunch of stuff in a separate document called a statement of facts. He was not charged with any of these things, but the state prosecutors, when they released the indictment, also released this separate document that said, well, here's some of the stuff he did. We're not going to charge him with it, but this is what he did. So that was the excuse for allowing into evidence this conspiracy theory, because conspiracy was in this second document. Trump conspired with Cohen, and he conspired with his own people to hide the payment process, the exhibit you had on that.
Exhibit 36.
Yeah, Exhibit 36. That was all said to be a conspiracy, and that was described in this separate document. But due process, in my understanding, requires that the defendant be told in the indictment what it is he is accused of doing.
it also said illegal expenditures. And you're saying there weren't any.
Exactly.
There just weren't any illegal expenditures.
There were not.
And that they were using doctored documents, but they weren't Trump's.
That's right. It was Cohen's. Cohen created a separate entity to borrow the money and make the payment, and several other related documents that he used to make the non-disclosure agreement with Stormy. Trump was said to be responsible for those kind of phony documents. I mean, there was no reason to create another company to make the payment or borrow the money. Trump was said to be responsible because he conspired with Cohen to get that done. But the indictment doesn't charge him with conspiracy.
It doesn't sound like a law school professor would score this very high in terms of how they brought this case.
You know who Alan Dershowitz is.
Yes.
He's a famous and still brilliant at the age of 85 constitutional law scholar. Taught law school at Harvard for many years and has been hired in multiple high profile criminal cases. He's still talking about cases, including this one, and he is up in arms about how this judge has handled this case. He minces no words. And he describes himself as, I am a liberal Democrat. I have voted against Trump twice, and I expect to vote against him a third time. But this is wrong.